still taking testimony in H342. I'm going to be changing the order of the witnesses somewhat. I definitely want to get the folks that are going to talk to us about the Vermont point of view first, and then we have a couple people give us kind of a national sense of things, and we're going to end with them because I want to make sure we understand the need, if any, from the point of view of the affected, covered individuals. And we'll start with Department of State's attorneys. Over to you.
Great. I was worried I was going to lose my spot in a second. For the record, my name is Kim McManus. I'm with the Department of State's Attorneys and Sheriffs. A heavy topic for today. To jump off of some of the questions that I heard earlier, will this bill eliminate threats to prosecutors? No. Could it help minimize threats and violence, potential violence to our prosecutors through minimizing the utilization of finding our private information online? Very possibly. I am not a data broker. I do not understand data brokering, if that's a verb. I don't know exactly how our information gets online or how it circulates, so I cannot speak to that. What I can speak to is that our prosecutors and our employees at all the various state's attorneys' offices receive threats. We receive threats fairly regularly. As you all know, we have at any given time right now approximately 23,000 cases. It would not surprise you that cases involving family disputes, domestic violence, and a number of the serious felony cases are the ones that would generally generate threats towards our prosecutors or towards our staff. We receive a variety of threats, ranging from death threats to individual attorneys or to offices in general. These threats can be made by phone, in person, in writing. But as far as the variety of threats, threats of physical and/or sexual violence, threats to property, like posting a prosecutor's personal vehicle and where that vehicle parks, and making public aware of that to do with that information, sort of what they will. Some of these threats rise to the level of criminal cases, which was noted earlier. We do have criminal statutes that would cover when these threats leak over and become criminal threatening, stalking, or if actual physical violence is done. There is a criminal component to address this. Our understanding of this bill is how do we minimize the personal information, my home address, my personal cell phone number, from being online and easily accessible. That's our understanding of the bill. And if that is what the bill aims to do, either minimize or eliminate our personal information online, we support that. We understand as public servants that the public has a certain amount of access to us. We understand that they may be able to find us at our office or at court. But what we very much like is for them not to be able to come to our homes, of course. As noted, Vermont is a small area. I can tell you my neighbors right now probably do not know what I do. I don't think they watch your YouTube channel. My apologies. No.
That's shocking because our viewership is up.
And you know, I may or may not share it with them. But to the point that was being made earlier, yes, your neighbors may very well know, you know, that a judge lives down the road or that state's attorney so-and-so lives next door. But our average defendant has to look for that information, whether it's asking around town or going online. Again, if we can minimize that information getting into the wrong hands, we support that. Just to give you a little perspective, and excuse me, can I grab one of these?
Yes, they're there for you.
Oh, thank you. I was hoping I wasn't stealing your water. We often like to report our numbers to you One area that we are not happy to be distinguished in is that we are more than likely one of the highest referrals to the Building and Grounds Safety and Security Office. We would highly encourage you, if you would like more information about threats to state employees, to reach out to Building and Grounds. And I believe they would have a lot of the hard data that you might be looking for. But what I can tell you occurs that if a credible threat comes in, Building and Grounds is involved. And as noted earlier, the office is looked at. They run through what with the attorney or the employee who's been threatened, they run through what the emergency plans are in the office, what your escape plans are, where the security buzzers are that you can buzz, whether or not more cameras need to be added. In Bennington County, they just recently added, I don't know if they're all new, but currently in the State House building in Bennington, where our state's attorney is located, there's a total of 46 security cameras. And a number of those were added because of repeated threats to a Bennington state's attorney individually and the office. So there's a comprehensive view of your workplace. And then you have wonderful individuals who really know their staff about keeping yourself secure, come and meet with you at your home. When I was a prosecutor, I had one threat. Now, we get a lot of threats. We get a lot of people who are not happy with us. Not all of them rise to the level of credible. I had a threat made to me, or a threat was made about me when an inmate was incarcerated. DOC felt that it was a credible threat. It was very specific as to what this person wanted to do to me when they wanted to get out. It was very graphic, very violent. And so I had the unfortunate experience, which a lot of our prosecutors have, of sitting in my home, having them assess your home and talk about things like trimming back your bushes or putting up security cameras outside. They make a diagram of your home and send it to the local police department so that the local police department knows sort of your entrances and egresses. They discuss this was the thing that really stuck out to me, where your Alamo is, which is your place of last stand. If you can't leave your home, where would you go to hide and wait for police to arrive? And how long will it take for police to get there? And they give you I think it was a 20-page document all about this information and how far away your local police department is, how long you need to essentially stay alive until somebody can get to you. It is a sort of otherworldly experience to talk through that. At the time, I lived in a 2-bedroom condominium with hollow core doors. I was like, I do not have an Alamo. I don't quite understand, but they talk through like, okay, well, here's what you would do. And they go as far as to talk about having certain medical kits in your home or in your car. So if you are injured, again, you can do what you can to protect yourself again until emergent services come. The other element that they take on, and we will get to the privacy piece in a moment, but I just think this is really important to understand that this does happen to prosecutors and other state employees. They talk about your car. They talk about identifying your car. I was fortunate. I had a green Subaru Outback at the time, like essentially anonymous in the state of Vermont. But they talk about parking your car at work, parking your car at home. The idea of being cognizant of somebody following your car and what to do and how to sort of lose someone or get to a fire department or a police department. And lastly, in this massive report that they put together, they look at your online presence and they see what's already available online. And they discuss, what you can do as an individual about that. So things like social media, how you can protect that. I had everything set to the most private settings, and they very quickly were like, oh, this organization is important to you. You spend a lot of time here, you spend a lot of time here, which was mind-boggling. And again, not what this bill would protect, but just important to note. So all of those sites I quickly shut down, wanted nothing to do with them. But they then talk about, whether your home address is available, your social security number, your birth date, your telephone numbers, and what sites they're available on. Now, my understanding, and again, it's been a few years since I had to do this, there are various private companies that you can pay to go on and essentially try to scrub your information from the internet. And then that needs to be an ongoing process. Again, my understanding of this bill is that we would have a mechanism to ask data brokers to not distribute or redistribute our information. So either if we've already taken it down and it's popped up again, we don't have to continuously be monitoring our information online. The one moment. So to whatever measure this bill can, in the words of the bill, cease disclosure or redisclosure and lower our private information from being shared. Again, we understand it will not eliminate it completely. And this bill, I don't think, purports to do that. But in any way that it can minimize where we are exposed online, we support this bill. The one thing we would ask you to consider is currently in the definition of covered persons, it only mentions prosecutors. Our victim advocates, our paralegals, our front office admin staff. I believe I told everybody there, yes. They are all equally susceptible to threats. During the time when I was a DV prosecutor, I had one credible threat where I had to go through this process. My victim advocate during that same time period easily had 3 that had to be done, and had multiple visits to her home to go through the same conversation. So we would encourage you to look at who is being covered and to expand that to our entire staff. And the municipal employee, that does not cover us. So just to note that for you all. Happy to take any questions.
Questions? Just one, Kim. Do you have a sense of what the universe of covered persons would look like? I mean, granted, I mean, specific to the state's attorney's office, just because, like, I mean, through your testimony, the way that I'm thinking about it is like there are far more people that this would impact than initially, we would even think about in the bill itself. So do you have a sense of how big that universe is?
I don't. I heard your point earlier of, sort of anyone can be threatened. I think this bill is directing that just because we've decided to do certain jobs doesn't mean we should be, our personal information.
Oh, no,
should
I
be
totally
exposed.
agree with that. I think that for myself too, even as,
right.
an elected official.
The one group that I did notice, along with our staff, judges are listed, court staff. I would be interested, and maybe the judiciary will bring that up. I mean, anyone who's worked in a courtroom or been out in the hall, court staff receive, I believe, a number of threats and would probably want to be included as well.
But do you think it would be in the thousands, tens of thousands of people?
Oh, goodness. Well, I would not think so, only because it's Vermont. So like our office alone, we'd be including
Couple hundred?
170.
Yeah, that's what I was
A
thinking.
little bit more. I would need to ask Annie real quick to
Yeah, no,
get our exact
that's-
numbers.
I'm just kind of curious to get my
Yeah,
head
so I
around
mean-
the universe.
Altogether of all those covered persons, I'm sure we hit 1,000,
Yeah.
but I don't think we're talking another digit.
Okay, thank you.
I wouldn't.
And I just want to thank you for sharing your experience with us. I think it's very helpful to hear what it actually means when someone is targeted. And it's helpful for us when we're considering the meaning behind this bill and whether it's necessary or not. And the only question I had was I think getting the data would be really helpful. Is the buildings and grounds data capturing like when they come into your home and they do the explanation and
I believe so.
Okay.
I wasn't able to get that before this, but I believe that's, they would connect, what their process is.
Yeah.
Again, and it's a wonderful service that is done for state employees that they provide that.
Yeah. Thank you.
Thank you very much. Really appreciate your testimony. So Judge Zone, we'll go to you when I see you're online, if you're with us.
We are. Good afternoon, Tom Zone, Chief Superior Judge. So I think it's going to come as no surprise that this is a policy decision for the legislature.
Thanks for coming in, Judge.
It's a policy decision that certainly could have significant impact on the courts in terms of the number of cases. Listening to the prior witness, it certainly appears as though this is something that could add to the courts, but the question then comes down to, well, is it something that's necessary in the event that it does? And we get back to the policy decision there. I have to comment, I see John Muffler on the screen, and Mr. Muffler in 2008 was someone who I got to first meet at the National Judicial College in Reno. And he was there still working for the United States Marshal Service, and he was talking about security. Subsequently, I became faculty, and I got to see Mr. Muffler speak a number of times. And it always struck me that, well, Vermont's different. And we talk about that because he would talk about how you should take a different route home and giving all these tips for security. And we would think, well, geez, there's only one way to get there from here. We can't do those things. And I think that there's a complacency that we can often have with security. And Representative Harvey was asking some very good questions about, well, we're in Vermont. People can find out where you are. It's pretty simple. True. The last threat we had was someone from Connecticut on February 19th, threatening to come up and do harm to a number of people. Could they have found out things online? And I say that because the issue of security is one that I'll let Mr. Muffler and others talk about in depth, but from the judge's perspective, we can tell ourselves, well, they're going to be able to find me if they want. But the question I have is, well, why would we make it any easier for them to do that? The individuals who are going to look at doing harm, certainly some of them may have the rationality to go to the town clerk and look up where you live. I suggest that oftentimes many of them do not have that rationality. Daniel's Law was built upon the killing of Judge Salas's son. That individual was not rational, and he came from out of state. And so I point these out as when we look at Vermont and say, well, it hasn't happened here, I think we have to add the word yet. And hopefully we add the words, and it never does. This type of bill is something that seems as though it takes a step towards protection of covered persons, judges, and others. I know that there are many reasons why people would look at judges and say, well, we want to go after this judge. Well, law enforcement, state's attorneys, others have those concerns too. And we certainly support the idea that public employees should not be threatened. I checked with our security head, Rob Schell, today, and he indicated that in 2024, we had over 250 threats. He believes about half of them would be including with judges and comments made or threats to judges. There's been increased contact with judges, according to Rob, and as I well know from my colleagues, and that contact is through home mail, cell phones or telephone calls. And so their information is out there and people are getting it. And the internet, as Rob points out, is being used to locate, communicate, and engage with judges in ways that hadn't happened before. And so this type of bill is something that, does it stop that from happening? For sure. I'll leave the experts talk about that. I think the answer is no. But can it minimize it and can it potentially prevent it? It would certainly seem that that would be a benefit. The judges who have previously contacted me about this type of situation are aware of companies called Delete Me and other companies who will go out and do things that will try to assist here. And I know there is support for the idea that anything we can do to increase the safety for the judicial officers, as well as, again, the other individuals who are state employees, who are public servants, we certainly would support that. I would have one technical note, and that is on page 4, line 20, under the definition of judge. I would change it to say judge means any justice, judge, or magistrate of a state court located in Vermont. And then say, and any judge or magistrate of a federal court. I think having the Supreme Court, Superior Court of Judicial Bureau raises questions as to whether assistant or probate judges would be covered, and it should be more encompassing if that is the intent. So I'm certainly happy to address any questions.
Zach.
Judge, thank you as always. I just have one question, and it kind of goes back to the definition of data broker. And and you brought up a very poignant point in terms of, individuals savvy enough to go to town clerks and look up brand lists and look up addresses that way. Would we be considering, because like I think of, where I live, all, the grand list and everything is, readily available unless, and your name is associated with it, unless you have it protected through whether trusts or LLCs. Would we consider town municipalities data brokers under this definition?
I haven't studied that definition enough to be able to give an opinion on that.
Okay. I think it's something I'm curious about. That's it. That's all I got.
Yeah, just writing that question down there again.
Because I do think, Chair, that the definition is the scale and scope is so broad in that we could really apply data broker to anything at this point that is a municipality. Could they potentially face litigation?
Tom Oliver, and then Angela.
Good afternoon, Judge. I'm reading the bill quickly here. It seems that as written, it would have to take some type of proactive work on the individual's part to make sure that they were not being outed by this information. And if you don't know that, how would it protect you? I mean, you would have to go back and have it scrubbed, and then take action if they didn't do something, correct?
If I understand your question correctly, yes, I believe you're correct, that the judge would have to take action.
Okay, so
The covered persons.
Yes, exactly. Okay, perfect. So if you didn't know where the source was, it could be uncovered. So unless you're out there doing research all the time, trying to find out where your main name might be popping up, is it going to help you? Not necessarily.
I actually asked someone who I know who is an expert in this field that very same question yesterday.
Okay.
And I'll let the experts, Mr. Muffler and others, talk about that, because I think they can enlighten the committee that yes, it does seem as though you'd have to know about it, but there are ways that you are able to do that, if I understand correctly from the individual I spoke with.
Right. I mean, I tried dodging one of your civil process servers once there for a long time. I think they finally found me at my home. I don't think they use the internet, and as a protected individual myself, I'm not so much worried about data brokers. I worry more about DMV information, things like that. If someone is committed enough to find you, I think they're going to find you. I think that's credible for everybody to say. I guess if you have to if they're willing to redact information in the sensitive areas, I would feel a lot better. Such as DMV. You can submit a request and boom, you get somebody's address. If it were redacted, I would feel better. But to worry about, I just never heard of anybody around here having used a data broker. to find somebody. That's all. I just want to see those statistics. I guess. No question.
Break it up a little bit, Tom, but I think we got the point. Angela,
Well, it's more a comment than a question, or, well, I'm trying
turn it
to,
into a question by saying,
Yeah.
do you agree or,
right?
right? Yeah.
Correct.
Correct.
Yeah, well, I'm looking at the definition of data broker, and it seems pretty specific to, it's a business or units of a business that knowingly collects and sells or licenses to third parties. And only when the information of a consumer with whom the business does not have a direct relationship. I think a town clerk is not one of those.
So without getting, we don't need to get into that debate because that is for commerce to figure out.
Okay.
They need to figure out the scope of data broker. We can say, please make sure that this isn't too broad, but I mean, it's like.
Well, I think missing from this argument might be, something that might be might be helpful is for us to really understand what data brokers do and how the information that this bill aims to protect gets to the internet.
So I'm trying to understand, like, Department of State's attorneys, the courts, if this is something that can minimize the access to that kind of personal information, they're a thumbs up there. That's all I want to really understand, because if we go down that road, let's take another week of testimony. It's because that really, from what I understand, even from talking to Rick, is that really you can slide into some pretty technical stuff that really is out of our bailiwick. So disagree that, I mean, yeah, yes, but that's not really a question for us to answer.
Right.
I mean, I'm taking it at really this high level. I've heard enough to say this will help. This will limit or minimize the ability of people to get addresses of these people we're trying to protect. That's about the extent of what I need to know for at least the part of the job that we're doing, which is to find out if that's helpful, if that's something people want.
Okay.
Does that make sense?
Yeah.
Because otherwise you're going to need another couple of days.
Yeah, okay. I just don't know that everyone understands how, and so you might not know if you don't know how. That's my concern, but.
But I think I'm just taking that it is going to help. I take that's from Matt, and I understand from that this will help, and so.
Okay.
And if it doesn't, well, then they shouldn't do anything with it when we kick it down the hall. Yes, Ian.
That's actually, I think, like, kind of how I'm structuring it in my head is like, if doing this with data brokers will reduce these risks, then yeah, totally support. And if Commerce does the work on the data brokers and finds that it doesn't, then yeah. But like, I think if all we're doing here is saying if that's what it would do, right, then.
Right, I'm trying to evaluate the threats that we're trying to address and get the opinion of the covered persons that we deal with. And we've heard from one who says, no, it's not going to do anything. And we've now heard from two that if it does something, great, we could use that help. That's what I'm hearing. So we'll go to the next covered person. So let's jump to Sergeant Mike O'Neill. If you could join us, thanks for being here, Sergeant. If you could join us and identify yourself for the record. And
good afternoon. My name is Mike O'Neill. I'm actually a retired sergeant. I've with the Vermont State Police for 28 years. And I'm now the executive director of the Troopers Association. I've been working for them now for about 7 years. I typed up some testimony, and a lot of the comments I've heard, I think what you're really going to hear from me is, yes, we support this, but I'll go through it. I don't understand data brokering. It's a great question. I hope that a bill like this could have the effect, the effect we're hoping for. I appreciate the opportunity to be here and testify in support of H 342, legislation that takes an essential step toward safeguarding Vermont's public servants, including members of the Vermont Troopers Association, from threats, harassment, and violence enabled by the disclosure of their personal information. Every day, Vermont's law enforcement, judges, prosecutors, and other public servants, and I think the list would be quite lengthy when we really look at all of them, place themselves in risk in order to fulfill their duties to the communities they serve. Unfortunately, in the digital age, their exposure to threats extends far beyond physical encounters. The unregulated access and distribution of personal information by data brokers pose a severe and growing danger to these individuals and their families, which is very important to always remember the impact that this has on families of people that are just doing their job. This bill provides a necessary measure of protection by requiring data brokers to cease disclosing the protected personal information of public servants upon request. The role of law enforcement inherently involves engaging with individuals who may have criminal intent, violent histories, or grievance against the justice system. In recent years, we have witnessed an alarming increase in targeted harassment and even physical attacks against officers and their families due to the personal information being readily available online. This is not a hypothetical risk. This is a present danger that we feel must be addressed. By allowing public servants to remove their personal information from public databases, this bill acknowledges that privacy, safety, and security of those who enforce and uphold the law are fundamental to the continued function of our justice system and government operations. H 342 does not impede the public's right to transparency or accountability in government operations. Instead, it strikes a necessary balance, ensuring that the personal address and contact details of public servants are not used as tools to intimidate or instill violence against people for doing their job. The negligible public value of the personal information is far outweighed by the risks associated with accessibility. The ability of officers to perform their duties without undue fear for their personal safety is essential, not only for their well-being, but also for the effective enforcement of Vermont's laws. Ensuring that they can do their jobs without undue concern for their safety or families fosters a more stable, resilient law enforcement community. For these reasons, we support this legislation and urge this committee to try to move this forward. And I know you're late in the session here and time may be difficult, so I hope that's possible.
Appreciate that. Questions for the retired sergeant? I guess that was it.
Thank you.
Yeah, I appreciate that. And if you could submit your written testimony as well.
Yeah.
That's great. I appreciate it. Very helpful. Oh, Tom has a question. Oh, Tom, sorry. Tom, go ahead.
Yeah, I always forget me, yeah.
Yeah, I didn't see you.
Thanks, Sergeant. Just one quick question, and my question would be, I hear you. I understand your concerns, for the same reason. My question is, upon request, to me, is a day late and a dollar short if you didn't know. And that's the weakness I see in this bill, upon request. If you didn't know somebody had your information or gave it away, it's a day late and a dollar short. Your thoughts on that?
Yes, I understand that. I guess my response would be that if this legislation is passed, I believe most people covered would make that request. Whether or not the information is already out there, you don't know. But at least if there's a starting point going forward, you can make the request. At least you can feel safer that a new situation isn't going to give somebody the ability to easily get your information, or at least that would be the hope.
But who do we make that request to? I guess it's also.
I wish I knew the answer to that. That was my understanding of how this legislation would work, and I have no idea.
Okay. Thank you. Appreciate it.
You're welcome.
And I think that part, again, Commerce will certainly dig into the actual machinations of how this thing would work. So thank you very much.
Thank you.
So we're going to jump over to the chief now. Chief Pontbriand, did I pronounce that even close to right? And I apologize if I didn't.
Close enough. Pontbriand.
I thought that's what I said. All right, over to you. If you can identify yourself for the record and proceed. Thank you.
Certainly. My name is James Pontbriand. I'm the chief of police here in Berlin. I'm also representing the executive board of the Vermont Chiefs of Police.
All right, if you could proceed.
Certainly. Very interested in this legislation. As chief, I kind of accept a higher level of accessibility and notoriety just in the function of my position. My concern would be for my line officers and having their information unduly exposed to bad actors. My concern with this legislation is there's already a process in place for people to have their information scrubbed if they're proactive. What it doesn't seem to address is non-data broker types, special interest groups that might be keen on distributing an officer's information, particularly when they're involved in a controversial issue such as an officer-involved shooting. There's certainly been many cases of an officer's information, their address, their personal data, their picture, family information being distributed on the internet with the intent of people camping out in front of that officer's home and making their life miserable. I would like to see legislation address that, with people distributing information with the specific intent of causing intimidation or fear for that individual.
Chief, can you repeat that?
Yeah, I would like to see legislation address non-data brokers who distribute an officer's information, law enforcement information, with the intent for that officer to be intimidated or harassed in some manner.
Right.
There are a lot of special interest groups out there that Operation Oversight, for example, continuously post people's pictures, all the information they get about their employment, where they're employed, all that other stuff on the internet. I can only assume with the intent that this officer face a higher level of scrutiny for whatever reason.
Right. Yeah, it just wants my mind that that could get into a freedom of speech.
Yeah, I mean, that's not this bill, I don't think, but I can see that we can dig into that further as an extension of what we're trying to do here. This is taking I think a smaller step than what you just have suggested. And I guess a question for you is, at least with respect to the data brokers, is that something you could see potentially? Well, forget who it is, data brokers, whatever, the higher level, if we make it harder for somebody to get the address information and phone number information of law enforcement, is that beneficial given the threats that you see to law enforcement?
Anything we can do to limit that information would be beneficial.
And this doesn't go far enough, I'm understanding from your perspective on that. And that's certainly something that we can continue to look at as well. And
I don't believe it does. And I do understand freedom of speech, but when it crosses the line with the intent, some kind of malicious intent, I think that's problematic.
Right. There's the true threat doctrine that we'd have to look a little deeper at and see, and that's something we can work a little bit more with state's attorneys as well, who have dealt with that, as well as certain people at the Attorney General's office that we've dealt with this particular question in the past. On how far we can go in this kind of scenario. Apparently, this bill doesn't cross the line. At least one court in New Jersey has said a similar bill has not. But we'd have to dig a little deeper at what you're talking about, I think.
Thank you.
Yeah, no, I appreciate it. Any questions for the chief? I don't see any questions. I appreciate your time. Thank you for being patient, and we will look. I will make a point. It won't happen this session because we only have 4 days left in the session. But I'll make a note to dig into that a little bit further, and maybe reaching out to you again on that as well.
Thank you, and thank you for the invitation.
Yeah, thank you. All right, so we're going to back up to John Muffler next. If you could join us on mute and identify yourself for the record.
Hey, good afternoon, and thanks for the invitation. My name is John Muffler. I'm consultant. My company is Equitas Global Security. I'm retired from the United States Marshal Service, where I oversaw the National Center for Judicial Security. And I currently am a senior advisor for Gavin DeBecker and Associates, advising clients on anti-assassination strategies and the assessment and management of situations that might pose a hazard to their safety or well-being. I've been with Gavin about 9 years. I had about 25 years with the U.S. Marshal Service, and I was specifically charged with assessing and protecting threats to our judiciary, court family, prosecutors. I find myself in a very unique position. A few years past retirement from the Marshal Service, conducting a lot of presentations and training nationally. I don't know how far you want me to get into my background at all. I can stop right there and get into some notes. It's up to you what you want me to.
Yeah,
how you want me to proceed.
why don't you proceed with talk a little bit about the situation and what this bill could do to address the situation?
Yeah, so I think what we're seeing, I think many states have legislation already on the books, as you're kind of saying, but in particular to a Daniels Law or some version of that, it's less than half the states have that. Obviously, they're moving forward with it, and I think one of the things with the privacy law or the PII, personally identifiable information, which is what you're trying to protect for certain government officials. There are two reasons why sensitive information should be hard to obtain. Potential attackers may never learn it, right? They may give up and they may pursue someone else. And the research bears that out, whether it's Secret Service data, FBI, or the Marshal Service. And the other thing is, the more difficult it is to obtain, the better chance of being detected in the process. And what I mean by that is, and I've heard a lot just in the short time we've been on for 38 minutes about what's credible threats and et cetera, those kind of terms. You have to understand that, the more hurdles you put up, whether it's this legislation or great locks, lights, and windows at your house, the better. I've heard also a couple times people say, if they're willing to get me, they're going to get me. Well, that's parochial thinking, and that'll just help them immensely succeed in carrying out that attack. And that's why legislation like this and a host of other things that Robin Moranti can talk about too is part of a full security system apparatus, right? There's so many things in play, but the PII legislation that you're talking about is number one. That is where judicial pursuers, public figure pursuers, those who are pursuing law enforcement and victims of domestic violence all go to those weak spots, which is social media and the internet. And so that's just currency for attackers. And that is where the mitigation needs to occur. And it begins with passage of legislation. And the other part of that too is, every state's doing it differently, whether it's Delete Me or Atlas Privacy or Iron Wall 360. You need another apparatus to scrub the internet. This piece you're talking about will be punitive and it'll be important, right? Because it's going to slow down those data brokers, if not stop them. You got to remember, you could fill out information for these data brokers because you have a legitimate threat or a threat of some sort. They can still post your family's data, right? And so you're going through all this trouble, but they can still find your kids. So I think, again, the legislation needs to address all of that. And, there are other experts out there that are, it's beyond my bandwidth to explain some of the specificities of these laws, but certainly those CEOs of the companies I just mentioned can give you some horror stories on that. So I think the legislation you're looking at is critical. I mean, it's critically important. I will just say this, and let me just kind of talk a little bit about research and why this is important. And this might be a little mind-blowing because it's counterintuitive. I've heard the word credible threat a couple times. I know a judge in Austin, Texas. She received a threat from the girlfriend of an individual who had a case before a judge. That person, that person's girlfriend called a DA investigator and said, my boyfriend, gave the boyfriend's name, is going to kill the judge in his case. Well, there's only one judge in that case. And that was the judge that was killed a week later. But the DA investigator blew off that threat as not credible. So the thing about a credible threat is interesting, right? And so when you look at the data, and this isn't John Muffler making stuff up, this is Secret Service data, this is Marshal Service data, you know, if it's counterintuitive. So if you receive a direct threat, you are less likely to be attacked by that person. But if you receive an inappropriate communication, which might be covered under the First Amendment, right? You are more likely to be attacked by that person. Again, the research bears that out. So any threat, any inappropriate communication needs to be investigated, and that's not part of this legislation you're talking about. I'm just getting on a little bit of a soapbox right here, because it's important to recognize all of that behavior, because all of that benign behavior can lead to threat behavior. And a lot of times does. So it's interesting that Vermont collected 250 threats. A half of that went to judges. And, you know, I'm hoping that every one of those was investigated by someone. There was an interview of some sort and a report made. Because it's important to, you know, you got to collect the dots. Half the states don't even collect the dots. Because then if you don't collect them, you can't connect them. Right. And so all of that is very important as part of an overall apparatus in threat assessment. And I think that's a big miss nationwide. So, you know, I'm on a little bit of a soapbox, but I think what you're doing is commendable. And I hope this legislation goes forward. But there are just other things to be aware of beyond, you know, credible, et cetera. So, keep that in mind. Let me just repeat those two things I mentioned earlier. 2 reasons why sensitive information should be hard to obtain. They may never learn it, right? They may give up. And the more difficult it is to obtain it, the better chance of being detected. And so that is the piece that is critical for those people who are being protected by this legislation, and those who have a fear of being stalked and intimidated, whether it's the law enforcement on this call, or the judges here also, or even the legislature. So those things have to be kept in mind, and you have to train yourself a little bit. You know, situational awareness, what fits, why is that person in my neighborhood, et cetera. Because we see that behavior carried out. It's a pathway of violence that we talk about. The research bears that out too, that pathway behavior. And so we're talking about, again, I'm just going back to my notes I took about that pathway behavior. If you have somebody is savvy enough to go to the town clerks, right, now to look for your stuff or send you mail, or you have information over your cell phone. In warning behavior typology, that's known as a fixated pursuer. That's problematic, right? That's somebody who is far down that pathway and likely closer to an attack. And so this is where the legislation becomes an inhibitor. It stops that person from finding that information. But all of that, going to the town clerk, getting mail at home, and receiving phone calls, especially to your cell phone, if it's your personal cell phone, not your government, that is very problematic. And that may not rise to the level of, say, an arrest, but in a mitigation strategy for law enforcement, that needs to be looked at. That's fixated, problematic pursuer behavior that is leading to an attack. So it all matters. Everything you're doing matters. And clearly this legislation is critical from stopping that person from continuing down that pathway.
All right, questions? Angela.
I have a question. Thank you so much for your testimony. I'm reminded as you're talking, I'm reminded of a training we received here in this room about what to do if there's an intruder in the building, most likely an active shooter. And we were told to shut the door and then basically pile everything up in front of the door that we can to impede that person's progress into the room or potential progress into the room. And I'm thinking of that as, is that a fair analogy that this legislation like this is one of those impediments potentially for someone who wishes to to do some work on.
Potentially, I mean, potentially it could be, because obviously you want to get the person to not come to that room, right? And that behavior is identified early on. Just think of a school attacker. You want that behavior to be identified early on and assessed early on, so you can mitigate that behavior, whether it's a Baker Act or an arrest or some other process. So, you stop them before they get there. Now,
Right,
again,
and so
there's one constant with what you do. You go to work every day. Everybody knows where you work. So I would hope that there's proper protocols in place if there's an active threat in the workplace, right? And I would agree with the barricade piece. Obviously, if you can get behind barricades and make that more difficult, because that person, in that person's mind, it's a body count for the most part, unless he's got a specific person he or she's looking for, but mostly it's he. So, you'd want to slow that person down any way possible. And so barricading obviously is one example of it. But let's go back a couple steps. If that person is of record, if he's one of the 250 people that your office is, identified, let's get into mitigation. Let's get into a threat assessment. Let's get into some mitigation strategy. Maybe that person needs mental health crisis intervention. So there's that older step of it, you know what I'm saying? But obviously, if they're already there and they're already coming in, then those are things that are, there's left of bang, which I'm talking about over here, which is to my right. I should say it like this way. And then right of bang is what you're doing to prepare when it happens, right? And so that's all part of that complete security enterprise that you have to have. So.
Right. And I guess to be clear, I was, not saying, will that potentially address the person who might actually show up, but is it fair to think of this legislation as one of those things you put in the way?
Yeah. Yeah, 100%.
Because we are here, it may not be not everything, but it's one of those things that we can do to help prevent someone from following through on a threat.
That's right. That's 100% right.
Thank you.
Any other questions? Tom, Oliver.
There you go. Thank you. So in your assessment of this legislation, do you think it's tough enough as far as protecting people, just being legislation, or do we need to make it harder to get people's information? Or, well, I don't know if you can do that, but what's your thought?
Me?
Yeah.
Yeah, I think if your legislation can mirror New Jersey's as close as possible, then you're in a good way. I really think that is the standard. I know other states have copied that. I haven't gotten too into the weeds on your legislation, but I know Robin's getting ready to come on. But if you, as close as you can get to that legislation, I think it's a home run. I know Delaware copied it, Maryland tried to, some version of it. And so, I think that is the standard, and obviously that only came to be because her pursuer, Judge Salas's pursuer, attacker, killed her son,
Yeah.
Unfortunately got, terrible, but hopefully this never happens in Vermont. So, but I think if you can copy that legislation, I know every state's going to be different and, there's lots of things in play there, but as close as you can get to that. Definitely.
Again, I go back to the fact that the person whose information it is has to be preempted to make sure it doesn't get out. And if you don't do that, you're going to be a victim. So I think that's going to be very oftentimes the case. I mean, not too many people are going to go, I don't have the time to sit there and, I've shut down my 3 credit bureaus so nobody can steal my, get credit cards in my name, things like that. But I don't know how expensive would it be to have to remove yourself proactive from the internet or whatever other sources that are out there.
Yeah, I think there's some personal choice here, but I think there's things that, perhaps government can step in and do some things too beyond the legislative piece, right? I can tell you personally, I purchased, a couple of these programs and, they work pretty well for me. But certainly you need multiple things in play. You don't just need one tool. If you only have one tool in your toolbox and it's this legislation, it's not going to work, right? Because, look at Judge Wilkinson in Maryland. Even if they had that legislation passed before he was killed in his driveway of his home, that was a domestic, no, I'm sorry, that was a divorce case. He followed him home, right?
Right.
So, but you need all these different things. You need to have a toolbox full of tools, right? Whether it's a home security system, a dog, not advertising how many stormtroopers kids you have on the stickers in the back of your window, advertised parking spot. These are things that Robin does daily and is working on. And there's so many little hurdles, like I said, you have to make it a little more difficult for them. But if they cannot find your information so easily, that's a massive, massive roadblock. And that's great.
And
That's what we do.
would you be one of the people that has the statistics, or would that be Robert?
There's tons of statistics, but
I'm just curious if there's any national statistics of which data um, holders may have given over information. So someone was found and there was a homicide.
well, I can tell you that, and I can go over, there's just countless stories with public figures, judges, legislators.
I mean, a
celebrities
homicide.
that
I
have
don't
been
need the
attacked.
stories. I've been tracked. I mean, I've been found
Yeah.
at home by people. I'm talking actually committing the homicide.
Yeah, I'm looking at the research that I was part of with the National Judicial College. Over 90% of judges in this country support this kind of legislation. 90.2. So
That's not what I'm looking for. I'm looking to find out
oh, I know
how
what you're
many.
looking for. Yeah.
All right.
One of the things you're going to find it difficult is that kind of research, that kind of data, but it's out there. There's certainly thousands of anecdotal stories that I can probably give you off the top of my head.
Right.
How the attack was successful because the information was so easy. Again, information is currency for these attackers, and that's
I
where they're
agree.
looking.
Thank you.
Yeah, no problem.
Other questions for one? All right, not seeing any. Before we go to you, Robin, I was going to go to Captain Barnes next. So if you join us, Captain, I didn't notice you sitting in the corner there, so I
Trying to avoid the sun. It's the first time in a long time. It was actually warm.
So we identify yourself for the record and proceed.
Ashley Barnes. I'm the Special Investigations Captain for the Vermont State Police. It's kind of it's an odd title. People don't usually know what it is. It means I oversee the Vermont Intelligence Center Arson and Explosions Unit and the Vermont Drug Task Force.
Okay.
So luckily for you, I'd say 90% of what I was going to talk about has been thoroughly covered. Michael Neal spoke representing the Vermont Troopers Association, the union. And so from the rest of the Vermont State Police, we would of course support this bill. For those of you who don't know, lieutenants and above are not part of the union. So I'm going to try not to repeat what was already said, but from like a personal standpoint, like I certainly have had death threats and other threats. And as law enforcement, we know the risks, right? We get threats at the barracks all the time, email, voicemail, it's part of the job. When you receive information by somebody who lives far from your community, that has your address, that lists your children's names, where they go to school, it hits home. It's very different. These are not people that are following us home from the barracks. In the instance that I can think of, the majority were found online. In one case, not with like a South Burlington officer, his information was found online and his address was put onto Facebook for other people to harass him. In my case, I received a few threats that listed where I lived, and my family threatened my life. So it's highly impactful on us, but we in some ways maybe sign up for it. Our families don't, our kids don't, our spouses don't, and they're equally, if not more, impacted by that. So I think that this is only one step in many ways we can protect ourselves, which is already been spoken of. But it will help cut that down immensely. And of course, being the state police, when there are threats to judges, other law enforcement, DCF, which I've experienced a lot. I feel like they get a lot of this specific to their homes and their addresses. We investigate it. So I can say without giving stats that the information obtained online is significant, and it's not always the we're following you home or we're going to your office. One thing I would like to see added under law enforcement is like our victim services coordinator who deal with all the same individuals, our victim advocates, our embedded mental health workers. They're just as easily targeted as well.
So the embedded,
We have they're called embedded mental health, or maybe they're mental health crisis workers now. They're in addition to our victim services unit. They fall under a different side of the house.
questions for Captain? We've covered a lot, so I appreciate that.
Yeah, going last maybe has its benefits.
Testimony. Thank you very much.
All right, thank you. Thank you.
All right, we'll go to Robin Morante. Did I pronounce that right?
You're close enough, sir.
Well, not never close enough. Go ahead and identify yourself for the record, and then I'll know how to pronounce the name.
All right. Good afternoon, everyone. I'm Robin Moranti. I'm the Chief of Court and Judicial Security here in sunny New Jersey. After receiving Vermont's invitation to appear today, I thought maybe this body might benefit from like a little bit of a glimpse into New Jersey's overall judicial security journey, if you will. I've had the privilege to work with the judiciary here since leaving law enforcement in December of 2013. Chief Justice Stuart Rabner and Director Glenn Grant had the foresight to create court and judicial security internally here in the judiciary as a unit in that year. And that was to address the increase in volume and severity of the threats that New Jersey was seeing. And under their leadership, they challenged me to assist them in creating an overall culture of security at that time. So this far predates, the tragic incident for Judge Salas. Security and threats against the judiciary there, as John Muffler says, and I appreciate the shout out. I've had the privilege of working with John a few times, and he's very astute. I would say to you that, again, these aren't new. And prior to that, ultimately, and it did lead to Daniel's Law in New Jersey, but New Jersey was moving incrementally forward towards a more secure environment for judges and court staff overall, knowing that the National Center, because I heard people talk about statistics, they have climbed significantly. You can find those statistics over open source. I can tell you, I review upwards of 3,000 reports a year here in New Jersey. Prior, again, to those events, again, we were moving incrementally. We launched an online platform that centralized all security-related reporting statewide, municipal through Supreme, because we understood that those reports would allow us to begin to collect intelligence so that we might risk assess and predict possible threats and problems, because there's a real, I think, sometimes intelligence gap in some of the states that do not have that centralized reporting. The real-time reporting platform, along with a 24/7 hotline, threat hotline, allows court and judicial security to coordinate with our law enforcement partners in a comprehensive way to meet the security needs immediately upon receipt of that report or that hotline call. In 2015, I, along with some external partners from the United States Marshal Service and Somerset County Sheriff's Office, created a task forcing program that relates to judicial security, whereby we it never stops here, my friends. And that program was a partnership between the United States Marshal Service, the New Jersey State Police, all 21 county sheriffs in my unit to address security concerns statewide. And it's called JSMART, the Judiciary Security Management Response Team. And that program is pivotal in New Jersey. And it allows for the judiciary and our executive branch partners in those agencies to work together to, again, address threats against judges and staff. And through that partnership, we begin to create training for judges and staff and law enforcement that bolstered our, overall response to incidents. But fast forward to July 2020, New Jersey was witness to this tragic event at Judge Esther Salas's home and the passing of Daniel. And the tireless advocacy that she did, putting judicial security on the map, understanding that this was not a circumstance that was abating in New Jersey or nationally. And for information privacy for judges everywhere, she was advocating for that, and I stand by her advocacy of that. I think Daniel's Law is an essential first step to enhancing security for judges without question. And I think many judges throughout New Jersey opt into the Daniel's Law program in New Jersey by accessing their online portal, in which the executive branch partners at the Office of Information Privacy administer that here. And that program allows for the redaction of information for law enforcement, judges, other protected individuals to be pulled out of governmental sites. And that, specific to executive and legislative branch. PII is bought and sold. There was a lot of discussion about data brokering. And anecdotally, I will tell you the example that I use with my judges when we're, advocating for them is that, especially during COVID, I don't think there's a soul out there anymore that doesn't have an Amazon Prime account, right? And whether you realize it or not, Amazon Prime or just your plain old Amazon account is a form of social media, because you get to leave reviews, you have a wish list, you are able to interact with others, and they buy and sell your information 50 times over. And it is definitely a challenge, but I think it is a worthwhile challenge. And the metaphor of the active shooter barricade door, I think, really does hold up, right? I get exactly where you're going. And I agree that metaphor is apropos in this circumstance. And even though it feels like when PII is bought and sold at the rate that it is on the internet, it's an astounding rate. And it's creating like this weird hamster wheel of information maintenance. And it's very daunting for anyone. But again, it doesn't mean that it's not a worthwhile pursuit, because some security is better than none. And recognizing in the wake of the tragedy and the passing of Daniel's Law, I think we in New Jersey knew that we could do more and we could do even better. And the Chief Justice and Administrative Director here charged Court and Judicial Security and our partners to build upon what we were already doing, comprehensive programs for security. And it's important to recognize that I think security can be very personal to folks. And because any security that's deployed comes with a potential cost or inconvenience, one size doesn't always fit all, right? I think it's important, and John spoke a little bit to, like, just the singular component of information privacy is really not fully sufficient. It's an excellent first step, and I wish all states would take it. But there's, I think, a lot more to do, and understanding that, again, led us to create a number of other proactive programs for our judges to engage in. We've trained and certified approximately 200 law enforcement officers statewide to do residential security surveys to help judges, target harden, or other threatened persons target harden their homes. And again, we certify them. They have to do a practical, all of that. In partnership with our IT division, the judiciary built a judicial protection profile where judges can enter sensitive information in the event they fall victim to a critical incident, and our law enforcement partners have to deploy quickly and safeguard their families and children. We manage, event security. And perhaps most significantly, I think JSmart created and ultimately New Jersey passed additional legislation in January 2022. And that statute allows a law enforcement officer to apply for a protective order on behalf of a judge, whereby they have found themselves victim of a crime. We have a lot of folks here that do get charged by New Jersey State Police who investigate threats to Superior Court judges in this state, whereby, whether it's a terroristic threat or a harassment or other indictable, our sheriffs who are in charge of protection can now apply, work with my office, and submit an application or a petition for a protection order. That also allows for, the removal of the ability to acquire weapons and the forfeiture of weapons if that individual does have, a permit to purchase, carry, or what have you in New Jersey. So again, I would credit the leadership here in New Jersey, and I want to thank the state of Vermont for the invitation to address your body today. I think most important takeaway, though, is that true security comes from continuous commitment and innovation and consistency and cooperation and coordination between the three branches of government. Obviously, I'm sitting here with you guys. So the success of Daniel's Law in New Jersey and any future legislation, I think that speaks to the security of the courts is a direct reflection of that intergovernmental partnership. And so I would thank you for the invitation. If I can answer any questions, certainly I'm happy to.
Yeah, thank you for your testimony. So, before Daniel's Law, and I'm talking about just the people that are protected in Daniel's Law, how many threats were there against those people, again, before the law, and how many threats are against those people now?
So I can't speak to Daniel's Law in New Jersey does cover law enforcement, and I don't track those statistics per se. I can tell you that before Daniel's Law, we were still getting upwards of 2,000 JIRS reports a year. We are now up over 3,000. But I think it's important to note, and I would suggest to the body that Daniel's Law in and of itself is not necessarily a deterrent. And I think there needs to be, it makes it more difficult for folks to get that personal information so that they can act out directly towards the judge. But there is a difference, and John started to allude to it. There's security issues, and then there's criminal ones. And sometimes when we can have something that is really small and on its face, where maybe law enforcement has no ability to charge, or there's no First Amendment issue or anything, as John was alluding to, an inappropriate communication. But when you look at a pattern of behavior and you see a number of those inappropriate communications, while not chargeable, could represent a huge security concern. And we see a lot of that in New Jersey, where it's not ripe for a criminal charge necessarily, but it creates an environment, because statistically also, as John was saying, the person that's jumping up and down saying they're going to kill you is not usually the one that actually does so. So
I'm just a little confused. Before Daniel's Law, there was 2,000, and then people's information was protected, and it jumped by 50%.
Well, what I'm going
to say, on face value, to me, it shows it's not working.
No.
Can I just jump in? Sorry.
I would be happy, John, to go ahead.
I think the law has nothing to do with somebody's behavior, right? It's not a roadblock. So, and it's not going to, the only thing the law is going to do is preclude somebody from finding that person, hopefully, right? Is not ever going to stop somebody from sending out a tweet and 1,000 more people jumping on that tweet in agreement that, I don't like this person, this legislator, this judge. So it's a law will never stop somebody's behavior from going forward, right? So I think that's a misnomer. And I think, again, one, it's mixing apples and oranges a little bit. It will and should preclude them from finding that information to carry out that threat, but it's not going to stop somebody from emoting a threat or sending out.
So can I just ask a quick follow? So the threats, the 2,000, the 3,000, those are not necessarily going directly to the address of the judges. Where do those threats come from? I guess that's the
State, yeah.
question.
So thank you, and thank you for the redirect. So those threats can come in a multitude of ways, right? They come in through pleadings, even. They come in telephone calls to the courthouse. They come in, through social media that we monitor, right? They come in a plethora of ways. They're not all ending up at the judge's doorstep. I think for me, the fact that what I see that typically increases the number of threats is public discord, acrimony in our societal acrimony, right? When we have that, we see threats increase exponentially.
So would it be right to assume that the 2,000 you were talking about before Daniel's Law weren't directly at judges or protected people, that they could have been retweets and that type of thing also?
My reports come in, and those reports are, they could be generic threats, they can be bomb threats, they can be threats against judges, they could be threats against staff, they could be somebody acting out at a service window where they needed law enforcement intervention. They can encompass a lot of things. The reason that we have that reporting system, though, is because when somebody is problematic in the court system, it's not, you can see their escalation or their decompensation, as the case may be, and that intelligence helps us to hopefully prevent, through a prediction or a risk assessment, what that individual may or may not be capable of.
Sure, and I appreciate that. I don't even know if you have the information that I'm going to ask you for, but I would love to see the direct threats that Daniel's Law
I can
covers, and the direct threats that potentially that we're going to cover, and what the number was before Daniel's Law and what the number is now, because that would tell me if it's working.
I understand. And certainly I can ask the administrative director whether or not those statistics are shareable with the state of Vermont, but I don't know if that is going to tell you if it's working. I don't know that it's going to. I think that there seems to be a belief where Daniel's Law is supposed to prevent threats.
Well, if my information is no longer available, people can't get a hold of me. So that would tell me
but they know that you're a judge, so they know where the courthouse is.
Right, but Daniel's Law doesn't cover the courthouse. It covers your personal information.
I understand, but our reporting system captures all of it.
And I totally understand that, but I to me, I don't need or want all of it. I want the part that would be specific to the law.
I don't know that
which would make total. Yeah,
I don't know.
That's what makes sense to me.
I don't know that we could break it down into those actors that arrived at judges' homes or sent things to judges' homes. I don't think that's not typically a breakdown that we would do.
I find that interesting because that's what the law is supposed to cover.
So I guess I would just ask a follow-up question then to Zach. I mean, what are the metrics or what are you looking at to see how the law is working or not?
Those statistics I think would probably come from the Office of Information Privacy. And certainly if you are interested in getting those, I can put you in touch with the director over there at the executive branch. But I think the only thing they're going to be able to offer you is whether or not what percentage of New Jersey protected parties are participating in that program. I feel you're trying to like prove a negative. I think it's a difficult question.
I understand. I see that John Muffler came on if he wanted to comment on that.
No, I was just gonna, I was saying it at the same time as she was saying it. You can't prove a negative, and I get where you're going. Oftentimes at headquarters in the Marshal Service, we would get questions like, well, why do we need so many extra deputies? Can you prove like that their presence is, creating less threats to the judges? And, it's one of those things that's very difficult to prove that negative, so but I understand the spirit of where you're going with that. But nothing's going to stop somebody from actually emoting a threat in some way, so.
I'm like confused.
I guess I would like to see in our bill the information of them talking about in a year or 2 years or 3 years if it's actually working. Not necessarily in spirit. I agree with the law, but it's been implemented for I think 4 years now.
I'm sorry. Does the state of Vermont have centralized reporting where you guys are tracking all of those threats that are any threat or inappropriate communication that comes in?
Well, somebody was talking about 250 threats to judges.
Okay.
Or 250 threats and half were to judges. So there is some information being tracked.
So I guess I would start with examining those and seeing how many of those threats that came in to judges have a nexus to their PII, their personal information. And then saying, okay, so if it did, then the breakdown, then you find out if the juice is worth the squeeze. How many people, because I understand that again, every security step somebody takes is gonna have, as I said, either a cost or an inconvenience or something. That's how security works, right? You get into, you go through a magnetometer, you gotta take off your belt and do the thing and you're delayed and all that. That's an inconvenience, but it's a security step. So, the state of Vermont, in contemplating what they want to do with regard to preserving PII for your protected individuals, when it comes to judges, you look at, okay, here's the threats that we have statewide. How many of these threats, if you have, specific reporting with accurate narratives, how many of them have a nexus or reference the judge's spouse or where they live, or did they call him at home, or was there a text message, or did they track him online, or any nexus to something that occurs outside the courthouse? That's how you see, how big of a problem do we have? I will tell you, I think that in the age of the internet, and given, what I see here, I would suggest that even without reviewing those, I think you're going to find a significant amount have some nexus to what would likely come from internet research.
Appreciate that. Thank you. That's it.
Thank you. I think, and Robin, I appreciate the testimony. I think, going off the vice chair's point, and what I know he's getting at is for a bill that seems so integral to, to to solve the problem, to protect these covered individuals, it does strike many of us as strange that there's no KPIs measuring that, whether that's data being taken down, whether that's a decrease in cases, whatever it might be. It seems strange that KPIs aren't readily available, and maybe those lie in the Office of Information Privacy.
Yes.
However, it seems like that office has been impacted heavily by private entities that are handling a lot of these cases, which brings me to my question is, following the passage of Daniel's Law, there was an article that came out in 2024 citing 130 lawsuits that were filed by Atlas Data Privacy. And I'm just kind of curious, are you tracking the number of lawsuits that are derived from Daniel's Law?
No. So because Atlas is a private company, the judiciary, if a judge wants to supplement the Daniel's Law portal with the removal from governmental sites with a private company, they will do that. The judiciary, that's not something that we track or that we have access to. That we don't have my office does not have a partnership with those private companies, and judges can contact with any number of those private companies if they so choose. I know that Atlas, based upon anecdotal information, I know that I think it's the PBA, have some sort of plan with them. But again, some folks sign up, some don't. It looks different for everyone. So it would be very difficult to track that. But certainly, again, I can put your body in touch with Christine Campbell at the Office of Information Privacy. She may have some sort of data that we do not.
Do you have any indication, and maybe this is the same answer, so stop me if it is, but do you have any sense of what the dollar amount of settlements that has been derived from these cases?
No, I have no idea.
So that would be their office. And so my last question, and again, maybe this is the same office, but do you have any evidence at this point that individuals are being solicited to sign on to some of these cases? Because anecdotally, I'll tell you what I've heard. I've heard that people are being solicited to join these massive class action lawsuits, and the data rows are being multiplied from thousands to tens of thousands to hundreds of thousands to, in some cases, millions of data files that are being leaked. And so all of a sudden you start seeing that compounding multiples of the 10-day fine and going out and out and out. And then obviously you have this, huge legal course of action. That's what I'm hearing anecdotally, but I'm curious if you're also hearing that in New Jersey.
I have heard that. Do I anything other than an anecdote? No, I don't have any direct knowledge of that.
But you've heard it anecdotally,
Yes.
but not direct evidence. Okay. That's helpful. Thank you.
Wouldn't Matt Atkinson presumably know that?
Yes.
But I'm also curious in terms of the judiciary, because they're the ones interacting with this.
Right, but I'm just saying.
And like she said, Matt is a private entity, so he really isn't going to have the information that we want. It's going to be
beyond what he's
right. That's my whole point, is that I think it's going to be the Office of Information Privacy, which has come up multiple times at this point. Thank you, Robin. I appreciate it.
You're welcome. And if you guys want that information, I can send it over through Nate, if you'd like.
Yeah, no, that would be very helpful. I appreciate that.
Okay,
And
I'll
I
certainly do that.
I think we're about to lose our quorum because of other meetings that are about to happen. So I really appreciate your testimony, and if you could get us that information, we'd all greatly appreciate it. So,
My pleasure.
yeah, thank you for your time and thank you for being available today.
Thank you.
Thank you, Tom.
Good luck.